I am David Pozen. I'm an associate professor here at the law school. I've been here 3 years. It's my great honor to be moderating this distinguished panel on privacy and transparency. Looking ahead, that's an intentionally broadly framed subject for our panel, and I imagine we're going to range widely over topics including data surveillance, reform efforts here and abroad, electronic privacy, and maybe also transparency around U.S. government operations, such as our drone programs. I'm going to give just a brief introduction of our eminent group of panelists to maximize time for discussion, and then give some very brief opening remarks before diving in. So I don't think our panelists need much introduction. On my left, we have Dinah PoKempner. Dinah is the General Counsel of Human Rights Watch, one of the leading human rights organizations in the world. She's class of '89 here at CLS. She oversees the organization's extensive programs on international law and policy, and most pertinent to our panel today, she's emerged as a leading voice in the post-Snowden conversations here and abroad on surveillance reform, privacy, and freedom of expression. Dinah is also an adjunct professor of political science at Columbia University. Next to Dinah is Lanny Breuer. Lanny is class of '85, and reunion chair for his class, for which we're grateful. He is currently vice chairman of Covington, but most pertinent, I think, to our discussion today, from 2009 to 2013, he was head of the Department of Justice's Criminal Division, in which role he oversaw extensive activities of the department on all manner of crime and fraud, but I think what we might end up discussing today, also the prosecution of national security leakers. From 1997 to 1999, Lanny was also special counsel to President Clinton. And then finally, we have Sarah Cleveland, who is a renowned scholar of international law, comparative human rights law, and foreign relations law here at Columbia Law School at the end of the bench. Sarah, from 2009 to 2011, was the counselor on international law to the State Department. Currently, she serves a number of roles for the U.S. government and in the Academy. On the UN Human Rights Committee, she's the U.S. member of the Venice Commission of the Council of Europe. She's also the co-reporter of the new effort to bring forth a 4th edition of the Restatement of Foreign Relations Law. Okay, so we could hardly have a more eminent group. I should say that some of our panelists, particularly Lanny and Sarah, have not particularly focused on privacy in their own work. We've therefore asked them to go a little bit outside of their comfort zone in discussing the topic today, even though they have a wealth of experience that bears on the subject. So I just want to say, by way of opening, that I think it's a strange time for conversations about privacy in the law today. On the one hand, there is unprecedented concern and international mobilization over our privacy as it relates to electronic surveillance. On the other hand, people often act in ways that suggest they don't much care for their privacy in the way they use the internet in particular. Scholars have talked about this as a privacy paradox. And the paradox basically consists of the following. Consumers and people say, when surveyed, that they care intensely about their privacy, but then they go and act in ways that don't reflect that concern. There are a variety of theories out there for why that paradox obtains. It may be that people don't actually care that much about privacy. The survey results kind of overstate their concern. Maybe they do care, but they lack information or meaningful options to actually exercise their privacy interests when confronted with Google or the like. So we have this kind of well-known paradox about the way people are anguished about privacy, but then go and give up their information rather freely in certain contexts. Professor Bernard Harcourt, on the faculty here at Columbia since last year, refers to our current state as the expository society. Now I'm going to quote Bernard. He says, we are not being surveilled today so much as we are exposing or exhibiting ourselves knowingly and willingly, with all our love, lust, and passion. We give ourselves up happily, voluntarily, in a mad frenzy of disclosure. We expose our most intimate details in play, in love, in desire, in consumption, in a stream of text, tweets, emoticons, and Instagrams, emails, and Snapchats, Facebook posts, links, shares, and likes. And what Bernard is getting at there is, at least in our interactions with companies, we seem to give up a lot of information, and yet we're particularly concerned when the government sucks up our information. Is there attention there? So that leads us to a second paradox that scholars have been writing about recently, and then I'm going to just turn it over to the panelists. The second paradox is sometimes referred to as the surveillance paradox. And it's tightly related to the privacy paradox, and it is that citizens overwhelmingly report being deeply concerned about government surveillance, and yet they often don't take steps to pursue meaningful surveillance reform, and surveillance reform indeed has been very slow in coming in this country, although recently we've had some significant developments. So just by way of framing our discussion today, I thought it'd be useful to get out those two kind of academic concerns about this whole area, which is our actions don't necessarily match some of our stated values and concerns. Okay, but to bring in our panelists, who we should really be hearing from, I thought I'd ask a broad opening question to everyone just to get us going, and then we can refine as we go. And I wanted to start with Dinah, which is, the question is this: basically, here we are almost exactly 2 years after Edward Snowden's initial revelations broke. He was still in that hotel, or just out of that hotel room in Hong Kong 2 years ago today, and when we first learned about the metadata collection program, PRISM, and the like. So he's now a household name. How has the world changed since 2 years ago with respect to privacy and data surveillance in those 2 years? And in particular, I was hoping Dinah could talk to us about the international conversation on surveillance reform, because his revelations have had ripples well beyond U.S. borders. So with that, I'll turn it over to Dinah, and I'm going to sit down and keep moderating on a lower level.
Thanks, David. Before I turn to that question, I'll just sort of emphasize that we're looking at this 2 years since the revelations began. And I think part of the problem of these disconnects that you put forward is that we've barely adjusted to the internet age. So of course there's going to be radical disjunctions between our expectations, our behaviors, our regulations, how we perceive the interests. And that's going to be sort of the theme of what I say, is that, wow, it's a mess. Recently, I was trying to help a friend who had been asked to write a chapter on the Lex Lata, the black letter law pertaining to cyber operations, especially in the context of cyber attack, with respect to human rights. And I laughed because, you know, it's almost impossible to describe. It's like trying to nail fire to a wall. So much is happening very fast, and there's so many challenges. So I'll sketch out a few of them. And I think you'll find that, you know, the paradoxes that the answer to the paradoxes that you've suggested is simply, hey, we've got to see how it plays out. Most of us, looking around at the proliferation of white hairs in the room, like mine, we straddle the analog and the digital age. Our kids are just barely adjusting to the shattering of their expectations of privacy. So I think it's a little early to assess. So this is what's happened internationally, and I'm going to sort of sketch a really broad picture here. All right, so Mr. Snowden set off a global firestorm over US surveillance with his sequential revelations. And it provoked international anxiety over the role of the US, as well as local anxiety in many countries about what their own governments were doing and how they were collaborating with the US. At the UN level, Germany and Brazil, very much stung by revelations of NSA surveillance of their political leaders, spearheaded two important GA resolutions that strongly criticized the US, albeit indirectly. The first resolution concluded by asking the UN High Commissioner for Human Rights to submit a report on privacy in the digital age. And then the next one, the year after, invited the Human Rights Council to consider establishing a special rapporteur on the right to privacy, which it has done, and I expect we will learn who the successful candidate in the application process is rather soon. And this action at the UN level was sort of framed by a series of reports by special rapporteurs on both freedom of expression and counterterrorism, expressing alarm about many activities that states engage in with relation to the internet, but particularly surveillance in the context of national security concerns like terrorism. So what we have is we have a very important UN High Commissioner report. We have a new mechanism that's going to start pronouncing on the right to privacy, which has been relatively unelaborated. It does not have a general comment. It doesn't look like it's going to get one very soon. But there's sort of, action about to happen. Lots of normative statements being made and interpretations. And I think we'll probably get into some of them, particularly the very hot topic of whether it's okay for a state to violate the rights of privacy to people who are not in its territory. But I'll leave that for the moment because it's a very complicated discussion. Now, these revelations considerably hardened and complicated ongoing discussions between the EU and the US on data protection, which some of you may follow. It's also estimated that they caused millions, if not billions of dollars of damage to US commercial interests because of the allegations that US companies had either actively collaborated or been raided by the US. But when we look at the domestic level, what effect have these revelations had? The strange effect, strange to me anyway, is that probably the US is in the lead in taking at least some gestures of reform. I think I'd describe them as quite modest, but at least some. When you look at it in comparison to the allies of the Five Eyes, the historic Anglophone intelligence relationship between the UK, the US, Canada, New Zealand, Australia. So many of these countries, Australia being, sort of appalling in how it's gone about it, the UK being stonewalling, they have been trying to push what I would say is regressive legislation, legislation that gives greater powers of surveillance, solidifies compulsory data retention on the part of companies, measures that have been, in fact, criticized by both at the UN level and at the European Court of Justice and also in the European Court of Human Rights. So we have this kind of almost revanchist movement in the legislatures of many of the Anglophone countries. France has not been helpful. France recently passed a law that also has data retention implications. It at least places many of the surveillance activities of the French state in the context of law. They were going on without explicit legal authorization, France's law being very outdated, but also has a sort of obnoxious feature of what they call the black box that the French government, by not judicial but executive authorization, can impose an algorithmic means of analyzing traffic patterns on companies in the name of countering terrorism. So this is sort of pattern surveillance and analytics. That got a great deal of criticism in France, but passed nevertheless. Why is all this happening? It's happening because of the perceived threats to terrorism and also the phenomenon of European and Western nationals going to join the fight with ISIS. And this has caused tremendous anxiety in addition to all the terrorist attacks that have been going on through Europe for the last 2-3 years, and has given great political steam to agencies that feel jealous of the NSA's powers or anxious that they are overly dependent on intelligence sharing by the US. So the legislative trend is fairly negative with a few exceptions. And Brazil, I think, deserves mention here. They created a sort of internet charter of freedom called the Marco Civil da Internet. It's somewhat limited in its effect because Brazil's constitution prohibits anonymous communications. So although it's, the Marco Civil gives a lot of play to the protection of rights, if you can't communicate anonymously, that sort of cuts out a whole swath of issues from legal protection under that law. So where does that leave us? It leaves us in a strange place where national legislatures are going one direction, UN mechanisms and interpreters are going another direction. In the middle, there is a wave of litigation, and this is, I think, to be expected. So civil libertarians, like myself, rather appalled by the revelations, but even further appalled by either the stonewalling or retrenchment of political bodies, are bringing lawsuits now to challenge laws that enable mass surveillance. I should probably focus on that as the issue, all right? We're all assuming that, but let's just be clear. The key issue here is bulk or mass surveillance that is perceived as disproportionate and probably unnecessary to the protection of legitimate interests such as national security. So no one's really arguing that you shouldn't be able to surveil people who are, for whom there is reasonable suspicion that they're involved in, crimes or dangerous acts. We're talking about blanket surveillance and collection of data and retention of data. So my organization has participated in some of this litigation in the US. I think in the US there's more of it than most places, but I should mention that it's going on in a lot of countries, UK, Germany, and a few others. Our notable cases are challenging the government over Section 702, the upstream surveillance that captures content of communications that are abroad. Of course, even communications between two US persons could be captured as they go abroad because the way the internet works, your communications could be routed around the world before they get to Poughkeepsie. So that's one challenge. We're also challenging Section 215, which has recently by the Second Circuit been ruled misapplied by the government and now has been revised through the USA Freedom Act. So that case may disappear. We've also challenged what have been revealed to be the sort of ancient origins of this blanket connection, the DEA mass surveillance. And even though it's over, we want the data that it collected deleted and destroyed and not shared or repurposed for any means. So that's sort of I guess a bird's eye view of the state of turmoil, and I'm assuming that others will get into the grass of what we're doing in the U.S. But I should mention that while there is this state of turmoil, at least in the U.S., there's now, I think, some sense of forward momentum thanks to the USA Freedom Act, thanks to the Second Circuit's recent decision over Section 215, thanks to these various legal challenges, thanks to the administration's responding to the concerns of its allies with Presidential Policy Directive 28, still a rather opaque and difficult to assess measure that I'm assuming now. Lanny will let us know all about.
Actually, if I may, I'm just going to ask, thank you, Dinah, for that great overview. I want to bring in Sarah next, actually, because of her work directly bears in some of these questions. But and I also want to talk about the USA Freedom Act in a little bit, not quite yet. I think we heard from Dinah that tough legislative domestic limits on mass data surveillance are kind of like commuting to work by public transportation rather than by car. Everyone's in favor of everyone else doing it, but not necessarily willing to do it themselves. Sarah, I wanted to, from where you sit on the Venice Commission and the UN Human Rights Committee, I want to know, does this capture your sense of what's happening abroad, that there's maybe some hypocrisy in the conversation or some tension in foreign countries' anguish over U.S. practices, but unwillingness to clean up their own houses. How do you see things from where you sit in those bodies?
Great, thank you. So first of all, I should say a little bit about what the UN Human Rights Committee is. It's a treaty body that was established by one of the main human rights treaties that the U.S. is a party to, the International Covenant on Civil and Political Rights. And it's a group of 18 legal experts who oversee the compliance of states that are parties to the treaty with their human rights obligations. States report to the treaty body every 4 years. The U.S. appeared before the Human Rights Committee about a year ago. Now, I should say in regard to that because I'm on the Human Rights Committee, I'm here in my personal capacity, and everything that I say reflects my own views and not necessarily those of the Human Rights Committee. I should also say that I'm recused from any Human Rights Committee activity that directly involves review of U.S. conduct. So what I say really in no way reflects the views of the Human Rights Committee. But that said, no, I do think that Dinah largely captured the landscape. I mean, the interesting thing is that, even the concept of the right to privacy, and I think we'll get into that a little bit later, but even the concept of the right to privacy itself is not all that well defined. It's not nearly as well defined as other human rights protections such as freedom of expression. And so when you take that reality and you add to it all the complexities that come with data surveillance and the ways in which cyber activity sort of defies the traditional assumptions that we have that action is tied to territory or to people, it becomes much more complicated. So I think Snowden, he radically changed the world in the sense that we now have very different knowledge about what governments are doing around the world, particularly the US and the UK. And there's a very robust international conversation about how we should be dealing with this phenomenon. But it hasn't gone a lot beyond that. There hasn't been major, I think, change in governmental behavior. And we're really, I think, very early in figuring out what the standards should be. I think many countries outside of Europe are thus far very content to point fingers at the United States and the UK without examining their own houses. At the UN panel on privacy in the digital age, for which the High Commissioner's report is included in your readings, Russia and China in particular gave very, very self-righteous statements about, condemning the electronic surveillance state, which, was interesting from my perspective. There's a tension between the US and the UK on the one side and others in Europe, Germany, France now because of the Charlie Hebdo attacks is moving in different directions. So the national positions in Europe are very complicated. I just wanted to say a little bit more about the state of litigation, because I do think that litigation is going to end up driving a lot of the changes that we see in the future, in part because these issues are so complicated and difficult to get consensus around to address them through other means first. So in addition to what Dinah said about the creation of a new special rapporteur on the right to privacy, the Human Rights Committee is now taking up this issue and did in its recommendations to the United States when the United States appeared, and I expect it will when the UK appears before the committee this summer. In Europe, there are challenges that have occurred in the European Court of Justice, and there are challenges that are percolating in the European Court of Human Rights. So the European Court of Justice, a year or so ago, issued an opinion in the case Digital Rights versus Ireland, in which it invalidated the EU data retention directive on privacy and personal data grounds. They found the directive that the EU had adopted to try to harmonize data retention practices within the European Union was disproportionate and allowed collection of data that was insufficiently tailored to appropriate law enforcement or other state interests. And then there are two major challenges coming from the UK, going up to the European Court of Human Rights. One is a challenge to the Tempora program of GCHQ, which challenges the UK's program of mass surveillance of internet traffic by tapping fiber optic cables going in and out of the UK. And the other, this was filed last month, and the other was filed last Monday, so this is all very new, challenging, this is a case in the UK's Investigatory Powers Tribunal, so right now it's in the national jurisdiction, challenging GCHQ's use of bulk personal data, which is essentially the equivalent of the 215 call data program in the United States. So once those go through the courts, we will have a much better understanding, at least, of what the European courts think that European legal standards have to say about these issues, but how that will relate to our own practices and the jurisprudence of our own courts is unclear.
Assuming that the
UK doesn't withdraw from the European
withdraw.
Convention of Human Rights. That's exactly right.
So let's
I take the position they can't, so.
Thank you, Sarah. Let's bring in Lanny now. So Lanny has a unique perspective, I think, as a former top law enforcement official on these issues. I'm wondering what they look like from where you sit or sat. And maybe also you might say a word about Edward Snowden himself. When the USA Freedom Act passed and was signed into law by the president the other day, you may have seen Edward Snowden penned a New York Times op-ed claiming vindication of his disclosures by the way in which they forced this conversation and eventually that legislative reform. Is that a fair accounting of what happened in your view?
So your original question was, how has the world changed since Edward Snowden? So after 9/11, the Justice Department started a national security division. And so when I headed up the criminal division, just to be clear, there was a national security division as well. So day in and day out, as the head of the criminal division, I didn't focus on these issues as much as my counterpart did in the national security division. But nonetheless, many of these issues were paramount. And then I stepped down as the head of the criminal division in the end of March of 13, and the Edward Snowden revelations, or Edward Snowden, became public a couple of months later, so I was already out of government. So I think what Snowden has done is he's created a public discourse, and for that I give him credit. I think this is an important public discourse. I think it would be wrong to think that the discussion and the debate about transparency and national security hasn't been one that those in the government and others haven't been struggling with for a long time. But I think Snowden made it front and center. But the challenge, and it's a very real challenge as we discuss what should or shouldn't happen, is that to a degree, as you discuss these kinds of issues, the government ends up having fewer tools that it can use in its fight against terrorism. Now, we can all talk about Snowden and we can decide whether we like it or not, but it's an inescapable, in my view, consequence of what he did, that as a result of talking about these things, the United States today has fewer tools than it had before. We can debate whether those tools are good tools or not. And I think it's also pretty clear that terrorists around the world, the terrorists are adapting their conduct and their behavior as a result of these revelations. So I think the United States has to decide, and I think Dean is right. I do think it's a leader in this cause, and Kate and I think the level of hypocrisy of other nations, and I adore Sarah, but even the United Nations to some degree is quite extraordinary. Because when there is a terrorist attack, when people feel at risk, they look to their government and nowhere else to protect themselves. And our United States citizens and residents have that expectations as they should. But the United States does have to decide, in my view, not just what it can do, but what it should do. And those are very difficult choices. David began by talking about how we act today. Today, most of us, and certainly our children, expose themselves, and maybe you'd say it's their choice, they expose themselves on the internet more than ever before. But to give you a very real debate that we had while I was AAG that goes right to this is, there was a conspiracy, there was a group that was engaged in going into people's computers and providing malware in the millions, We were able to figure out where it was. We had a very carefully constructed undercover operation to do it. And we had to be very careful in how we were going to disclose it. So here was the debate. We understood that what this group was doing was affecting by putting malware into millions of people's computers in the United States. Millions. And we had a way that we could stop it. But to stop it, we would have to figure it. I can't figure out. I'm not good enough to tell you how to do it. But our experts said the way we could do it was that we could send through a server a signal to the millions of computers that were being affected, saying to each of those computers, go to sleep when this particular malware comes into your computer. I'm sure I'm not saying it correctly. So our debate was, were we violating the Fourth Amendment rights of our citizenry? Were we? If we were going into your computers without your permission to tell your computer to turn down the malware? Well, that's a real debate. And those are the kinds of decisions I want everybody to think about, because those are the very real kinds of decisions, and everybody here can decide, I don't want anyone going into my computer, I want my malware, or I want the government to be able to protect me and to turn off that malware. Now, in that particular case, I think we came up with a construct. We didn't really know what to do. In that case, we found a federal district court judge. We explained to the federal district court judge what we wanted to do. The judge was as confused, candidly, as I was. But he finally decided, and maybe it's a little like the Pfizer court, he said, go ahead and do it. So my only point in all of this is that I do think these are very hard decisions. And the other point that I want to make about Edward Snowden is, when we talk about the bulk data, and everybody can decide what they think about it and how inexcusable it is, you've got these machines out there collecting gazillions and gazillions of pieces of metadata. Lanny, Breuer, and millions of other people's data is out there about, I guess, who I called, when I called, and how much. The likelihood of any human being ever looking at that is almost non-existent. But it is there, and I'm not saying it's good or bad, but it is there if, God forbid, there's a crisis, and you've got to decide overnight what you're going to do because you think there's a terrorist attack. And I guess people have to come to grips. Do you find it incredibly offensive that somewhere all of this data is being collected? And on one level, it's incredibly offensive and jarring to say that the government is collecting all this information. On the other hand, it's some machine somewhere that's collecting all of this data that probably will never see the light of any particular person. And I think that that's just one issue we have to think about. And then the other point I just want to make about Edward Snowden is at the same time that he disclosed this, he disclosed many other programs. And today, as a result of those programs, there are people who are at risk, or there are people who have been hurt, or there are programs today around the world who are less protected. And every day in this country, we need to know, as we all sit at places, and I'm not trying to be emotional, I'm just saying it's a debate. Well, we sit at lovely Columbia Law School. You should know that one of the reasons we're safe is because there are operatives and people all over the world that are addressing the kinds of risks that I became aware of as the criminal division head. The National Security Division head knows more about it. The Attorney General, others do. Edward Snowden, through his programs, made many of those people and many of those programs more at risk. And I think as a result, I personally think as a result today, we're less safe.
Okay, thank you. So Edward Snowden's himself and his lawyers would no doubt contest that last claim. And one frustration, at least I have, is I think it's so hard to know, but it's an important issue in thinking about what happened.
David, can I say one other thing? I don't want to be too emotional, but as head of the criminal division, you know, we are in a democracy. There's nothing preventing Snowden to come to the United States to face a fair trial if he feels. I mean, I know people smile. He has the ACLU. He's going to have the finest lawyers in the world. We're a great constitutional democracy. If he's so confident he wants to make his case, he can come here and he can face the consequences. And I'm not exactly, and he can later on ask for a pardon if he wants, if he's convicted. But I mean, there is something about this, right? I mean, on one level, he is being a paragon of liberty. On the other hand, he's in Russia. I mean, and I'll leave it at that.
Lanny, actually, I'll follow up directly on that, if I may, and then also ask about the USA Freedom Act. So as people in the audience may know, what Edward Snowden says often about why he won't come back to stand trial, among other reasons, is that he won't be able to make out the kind of defense he wants to make out, which would kind of invoke the public interest that he says he served. There is no recognized public interest defense to the criminal provisions under which he's been charged. That's true here. That's actually also true in other democracies. So to make this a little more concrete, a professor at Harvard named Yochai Benkler recently put out an article in which he said, what we need is a new public interest defense for national security whistleblowers. And we can't just allow whistleblowing to happen left and right, or we'd invite informational anarchy. We still need these criminal laws on the books, he says. But the difficulty raised by a case like Snowden is a lot of people think the First Amendment and democratic values served by the leaks justify them legally, and so punishment is not appropriate. So this defense should allow the defendant to argue that specific objective data points support his or her actions. In this case, did congressional hearings result from the disclosure? I think also newspaper editorials, and did legislative reform happen in light of the disclosures? And Yochai Benkler suggests that Edward Snowden comes out looking quite good as a candidate for this new public interest defense, which doesn't yet exist, given that all these things did happen in the wake of his revelation. So do you think this is something Congress should consider, court should consider constructing as a, out of the First Amendment or a gloss on the Espionage Act? What do you make of his argument that without that kind of defense, among other things, it's just fundamentally unfair to stand trial here?
So I haven't read the professor's piece, and so I don't know about it. I'll tell you what worries me. Look, in the real world, when you bring these kinds of cases, or you bring the leak cases, which I think we're going to talk about, the United States has a real challenge. And we can debate it on both sides, but the United States can introduce lots of information in a trial because it's classified and it's protected. And often in these kinds of cases, leakers blackmail the government. You can say they're good or bad. They say they have to disclose all of this information for a fair defense. And they know what they're really saying is, we need to disclose classified information that we and our lawyers are calculating the United States thinks is so sensitive to our security and safety that it can't be disclosed, because if it were, people and either sources and methods would be compromised, people would be compromised and the like. I worry that this is just another avenue for Edward Snowden to do that. I mean, I'm happy to look at it. I'm not against it. I'm always happy, and I believe in discourse. And I began, by the way, by saying, and I want to be clear, I don't want to be so critical, I do think that what Snowden has done on the positive is he has created a discourse, and I like that. I think the American people and all people have to really weigh for themselves, on the one hand, what are these risks to our safety and to our privacy? I think it's hard. And on the other hand, what are the consequences if we don't do the kinds of programs we do? So I think on some level that kind of discourse is okay. I probably wouldn't create a Snowden exception right now, but obviously it would be something I'd want to learn more about.
Thanks. I think Dinah was going to weigh in.
Yeah, I just wanted to, probably no one will be surprised that I disagree a lot with how Lanny's approach. I do disagree a lot with how Lanny's approaching the issue, but I wanted to just take up a couple things that you said, David. First of all, there actually are some countries and Western democracies where public interest of the whistleblowers' revelations is taken into account. I don't want you to think that this is sort of a wild theoretical construct. Moreover, there's a fair amount of international normative interest in this. Very shortly before Snowden came forward, in fact, a set of expert guidelines known as the Chani Principles was formulated that, in fact, calls on governments to create avenues for national security whistleblowers to safely reveal information, and even avenues for their protection should internal disclosures and monitoring fail, as well as a post hoc defense should the public interest in their disclosure outweigh the public's interest in national security. the problem that Lanny mentions of the government being forced to, disclose secrets in order to, show that actually harm was done, it is a problem, but, the courts do keep things quiet. You can't have confidentiality of disclosure. So we're not talking about something that is an unheard of, insoluble problem courts have never dealt with.
But juries have to hear it.
And the problem is that you can create, I'm sure that as human beings we're inventive enough to figure out ways to handle that problem if we so choose. But the problem is also that every time there's such a disclosure, there are these sort of vague allegations made by government officials that, oh, many people have been harmed, national security interests have been harmed, and virtually no details at all. Moreover, Snowden's disclosures were not simply that the value of them was not simply that we need a public debate. It was exposing rather gross failure of oversight, overreaching secret court interpretations of the law, as well as positive lies by government officials to Congress. So I think that some of the things that he actually revealed are not just in a kind of new, hazy, nebulous, theoretical, maybe there's some public interest in this, construct. It's pretty classic whistleblowing, government lies, abuse of authority, going outside the law, violations of the Constitution. I mean, I think this is sort of, not as far-fetched as maybe we're giving the impression. So my view is that maybe we're a little bit further along in terms of normative development than has been suggested.
Just for one moment. I don't disagree with Dinah, and I hope I'm clear. I think I said in the beginning, I do think that Edward Snowden has promoted a real discourse, and I do think it's important to shed light, and I do think it's important to discuss these issues. I just don't think he should be deified, and I think a fair reading of this man is that there are also very negative consequences to what he did. And also, it's not as if he even tried to go through the normal, maybe it wouldn't have worked, but Edward Snowden didn't even try to use the systems in place that this government has for whistleblowers. It's not as if you cannot.
I just have to interrupt because there are no systems in place that this government has that would have covered A, a national security or intelligence whistleblower, B, who was a contractor. There simply isn't. So, and C, Mr. Snowden, being a rather bright young man, had watched a whole series of people who in theory were covered moderately by existing laws because they were regular employees, in fact, high-level employees, be mercilessly punished both in terms of job consequences and legal consequences. So he wasn't an idiot. So, I mean, I think that's somewhat disingenuous.
So I'd like to bring in Sarah. I also, there's
I'll leave that disingenuous alone.
endless amount to say on this. I think technically Snowden could have availed himself of some whistleblower channels under law. There is something faintly absurd, I think, about what that would have looked like because you're supposed to go first to the agency inspector general, then to designated committees of Congress. And his critique was not this pointillistic abuse here or there that could have been easily rectified, but almost a total critique of the agency's operations, which had been blessed by the FISA court. So it's just amazing to think about that moment when the inspector general says, "What's your problem?" And he said, the entirety of NSA surveillance is a massive constitutional violation. I think it's tough to think about how to accommodate total critics like that within a whistleblower system. I think it's part of what makes Snowden so interesting and problematic. But Sarah, I want to bring you in on any of this, but also just to get a little more concrete about what Snowden has wrought. Most recently, it's the USA Freedom Act. And as Lanny was suggesting, the single most inflammatory revelation of Snowden was of the Section 215 of the Patriot Act bulk telephony metadata collection that was going on of almost all Americans' phone calls. That is targeted by the USA Freedom Act, and now the NSA doesn't do that anymore, although the phone companies are told and required and paid to do bulk telephony metadata collection, which the NSA can then access under certain conditions. The Act also has some new reporting requirements. It has an amici at the FISA court, and it declassifies FISA court opinions. It does a number of things, but does it add up to meaningful surveillance reform, in your view, or not? And I also last thing I'll say is it doesn't really address the privacy interests of foreigners, and especially from where you sit. Is this a glaring hole in the legislation?
Thanks, David. Just on the Snowden whistleblower point, I think, one problem with conversations about whistleblower protection is that whistleblowing is, it's an ex post facto remedy. And I think the really core question raised by Snowden and raised by WikiLeaks and raised by Bradley Manning is, do we have a fundamental problem with overclassification in the United States government? And if so, how do you create structures within the government that incentivize transparency rather than incentivize confidentiality, so that the government will be more transparent to begin with, and programs like the ones that Snowden disclosed will be put through a democratic decision-making process in the first place, rather than our trying to have to retroactively fix them. Big challenge, I think. On this, yes, I think the USA Freedom Act, for the reasons David said, we're better off with respect to Section 215 after the new reforms than we were before. Many in the advocacy community think that we should have gone further, and they should have simply let 215 sunset on the grounds that, among other things, the Justice Department Inspector General's office has not been able to attribute any important national security revelation or success as a result of the 215 program. But it leaves glaringly in place the Section 702 program, which is the data collection program for foreign intelligence targeting non-US persons who are reasonably believed to be outside of the United States. Now, many in the US are worried about this program because of the way that data travels. What does it mean to be reasonably believed to be outside the United States? So it could end up scooping up, this program could end up scooping up a lot of data communications of US persons. But more importantly for the rest of the world, it authorizes the collection of everyone else's data. And the USA Freedom Act doesn't touch this at all. So we've had a major problem in the international conversation with other countries, and actually with some significant diplomatic adverse diplomatic consequences. When we stand up, U.S. government officials stand up and say, well, we're looking at reforming and strengthening the protections for collection of U.S. citizens' data. That doesn't help us overseas at all. And there have been a number of steps, including before the USA Freedom Act. President Obama, a year ago, issued a presidential policy directive that made a number of reforms, including promoting further transparency. Obama stated in that directive, the directive on signals intelligence, that, quote, all persons should be treated with dignity and respect regardless of their nationality or wherever they might reside, and all persons have legitimate privacy interests in the handling of their personal information. U.S. signals intelligence activities must therefore include appropriate safeguards for the personal information of all individuals, regardless of the nationality of the individual to whom the information pertains or where that individual resides. So you have a broad policy statement by the president that, we recognize as a matter of policy that everybody has privacy interests and we're going to do the best we can, consistent with U.S. national security interests, to protect those privacy interests. Very unclear what that means, even as a matter of policy, let alone as a matter of law.
So I would love to keep asking lots of questions, and can if people don't step forward, but I'm told that now's the time to open it up to you, and I think we should feel free to follow up on all that we've been talking about. If people want to focus on other aspects of the privacy and transparency debate, that's fair game too, I think, including we haven't yet gotten to talk about transparency around the U.S. drones program, which I mentioned in my opening remarks. I think that's fair game too. If you wouldn't mind identifying yourself when you ask your question.
Class of 1980, Bob Goodman. I'm a lawyer in Dallas, Texas. I've had a case recently in which a member of a city government was sought to be removed in a public hearing over a statement he made on a LinkedIn profile that could be exaggerated to be defamatory related to Islamic terrorism. The statement itself was perhaps ill-judged, but it was not some horrible statement. And there was a public hearing, which should have been an executive session, because in Texas, city governments are supposed to consider personnel matters in private, but be that as it may, it was not. And his name and the meeting became the darling of websites all over the world, mostly in the United States, but certainly they picked up video from the hearing, from the city's website, et cetera. And it raised to me a lot of privacy issues, the chief one being, to use the paradigm of defamatory versus private, but true, a private true fact being used in a very defamatory way by advocates on either side of an issue. And there is no regime in the United States that exists as such to remove offensive content concerning a particular person from the internet. Raises all kinds of privacy versus privacy issues that the professor talks about in his article, or privacy versus the free flow of information type issues. But do any of you have a sense of how that regime, which I understand exists in certain European countries, is either flourishing or languishing? And with this attack in Garland about a month ago, that was certainly tied to this disclosure of this stupid event relating to, how good could you draw Muhammad, obviously giving rise to an attack.
Yeah.
That's a related issue. So my question is really about the remove an item from the internet regime, and then there are broader privacy issues which I may also be implicated.
Oh, great. So I understand the question to implicate the First Amendment, perhaps hate speech, and the right to be forgotten. I don't know if Dinah wants to weigh in on, and I think you're also suggesting that the U.S. is not where a lot of the rest of the world is, particularly in Europe, about the ability to remove from the internet, or the requirement to remove from the internet things in one's past. Dinah, do you want to speak to that?
I can speak briefly to that. The particular example that you gave, where, if I understood correctly, a public figure makes in public a statement that is then picked up and misconstrued and used in prejudicial ways, I'm not sure that even European regimes would protect you in that situation, because, the controversial statements of public figures are considered to be of pretty high public interest, regardless of whether people misconstrue them or make a fuss. But yes, Europe has a much more elaborated and recent law by the European Court of Justice on recognizing a right to be forgotten, and it's very controversial. It's resented and resisted by American internet service providers. And, of course, journalists are quite nervous about it. Of the hundreds of thousands of applications that poured into Google within days of the decision, many of them came from exactly the kind of people you would think the public would not really want to forget, people with criminal records who wanted them to be forgotten, who are in some way in the public eye. But that said, the U.S. has, in its common law and in its state law, had a strain of right to be forgotten, in that we value, for example, forgiveness and reintegration of people who have served their time, and have allowed them, for example, to not have to disclose their criminal records in certain contexts, like job applications. This obviously creates a problem because this information is always available on the internet somewhere. So this is an interest. You put your finger on a hot topic, developing, debate on both sides of the pond. Probably going to be subject to continuing jurisprudential development. as well as legislation.
Just a quick, there was a question about what decision you were referencing, just a European court decision on a right to be forgotten that would require Google to set up a process whereby you could petition to have certain information about you on the internet removed from Google's searches. In a nutshell.
Thank you very much.
Yes.
I will just say the original comment was on a private LinkedIn statement, which, you know, it's just the complicated quality of this issue is just illustrated by that fact. And then it became a cause célèbre with the city council meeting.
Thank you. So let's get some more questions in the back, please.
Something that Lanny said.
Would you mind speaking up? I'm sorry.
I wanted to clarify something that Lanny said when you said, you know, it's that collection of metadata is a huge amount of data that, you know, how could anybody possibly go through? But we forget that we're one of the brightest nations that there is, and we have people who are very smart. And I believe that Jonathan Meyer of, forgive me, Stanford Law School has written at least one article showing mathematical correlation and analytic correlation about how correct some of the assumptions and the outcome of certain analytical data to prove that people were at a certain place at a certain time having had this many phone calls with someone. And it is kind of frightening. I don't know if anybody's seen Citizen 4, but Snowden does talk to a group. There's a brief scene where he talks to a group and he explains to them that it's very possible that the police and other people, you know, can determine whom you've talked to. But there's another side of this. And this is my question to you now, is that right now, as of today or yesterday, we found out that Chinese hackers know all this confidential information about federal employees and about background checks. They know everything. And to me, this is a privacy concern because honestly, when we submit to background checks and things like that, we really don't expect this information to be out in the public. And now it is. And so, like Lanny said, people look to their government. What is our government doing to protect us against these things? I mean, you know.
So you raise an incredibly great point. On your first point, I just want to be clear. I was not meaning to minimize at all the bulk collection. I was just saying that people have to themselves determine in their balancing of all of these things how intrusive they feel that bulk collection is. And I think it's great that the U.S. Freedom Act is making changes clearly in the right direction, maybe not enough. Look, you raise an incredibly difficult issue, and it, on some level, candidly goes to sometimes the hypocrisy of this discussion. I mean, there's some things I can say and some things I can't say, but you're right. I mean, I'm probably one of those federal employees, and they have all, and probably it's about the third or fourth time that the Chinese have gotten my information in different ways, and so it's a problem. The answer is I think our government's trying to do a lot. I'm not sure that our government is able to do enough. I mean, I'm obviously not an expert, but it's a huge problem, and it will just continue to, in my view, to be more of a problem. So,
Sarah, you want to jump?
On your first point, one of the core debates with respect to the application of the right to privacy in this context is whether mere collection of data itself is an interference with the right to privacy, or whether it's only at the point that the data is trolled for targeted information. And the US government has taken the position that collection is okay, bulk collection is okay, it's only the use that we should worry about. In Europe and in international human rights contexts, people tend to be more concerned about the chilling effect or the potential chilling effect of the mere fact that governments have access to and are collecting this information. And it raises a really fascinating tension between public and private contexts here, right? Because private companies are collecting all kinds of data about you all the time, and every time you get onto a website and you get all these pop-up ads and everything, remember to buy this that you were shopping for and so on and so forth. That's because somebody's retaining your data and giving it to somebody else without your permission, or maybe because you checked on some shrink wrap contract agreement at some point on Amazon.com. So private companies are collecting all kinds of data for commercial reasons. We've been, in this conversation, much less worried about that than the possibility that governmental collection would be abused. But at some point, we're going to have to sync up this conversation.
Okay, so I think in the interest of time, one last question, wish we could go on longer.
I have a question. We talk about how malleable the information is. Has there been any instance where the government has actually created a story based on all the information that is available against someone that they just do not like?
Right.
Like a political figure or just so.
Oh, sorry, is a question about situations where this bulk data collection has led to a national security victory, or to the contrary, a situation where the collection has been abused?
It's been abused to create a story, because there are a lot of political figures out there. You know, we have people who speak out against the government that the government just doesn't like, who's not necessarily involved in any national security conduct, but they'll just create a story given the amount of information that they have.
So I'll just say that the ghost of Hoover's FBI, I think, looms over this conversation. In the Church Committee report of the 1970s, which led to FISA's enactment and the first wave of electronic privacy initiatives at the federal level, revealed that Martin Luther King Jr.'s sexual affairs were being recorded and used against him by Hoover's FBI, and so that's a history that's typically cited here. But if you want to update that,
Yeah, no, I was going to say David's point, which was I was going to say that the scenario that you draw, which is a very troubling one, is government misusing its authority. But it's not one in your hypothetical of government collecting bulk data and doing it. Rather, it's targeting someone they don't like, which is, you know, of course, in Hoover's FBI, whether it was Martin Luther King or others. And so that's just something a government has to be vigilant about, regardless of the issue of whether bulk data should or should not be collected.
And you don't actually have to have the government reading the content of communications in order to abuse data in this way, right? Because if you're collecting signals data that shows where a person moves on a daily basis, you can detect patterns of behavior, that they go to X mosque and they meet with X people in X cafe and so on and so forth. And you may well be able to create patterns to target people improperly based on that kind of data.
I would say that there hasn't been some kind of great, big, obvious scandal of abuse, although there have certainly been smaller revelations of abuse. Even now, we understand that the FISA court has been regularly chiding the government for not staying within its collection mandate. But I think one of the key things that I would keep a watch on is when intelligence is collected for intelligence purposes, but then used for law enforcement purposes. So there is this phenomenon of kind of backwashing, that you pick up all this data, and then one agency lets the other agency take a look, and then the request for the surveillance order to get what you already know exists issues forth. And your defense attorney doesn't have any idea how it came about, or suspects that it came about through an unlawful type of surveillance. And when I say unlawful, I mean unlawful in an international sense, in that the intrusion on privacy has to be both necessary and proportionate for a specific purpose. And the purposes of law enforcement and the purposes of national intelligence gathering are quite different. In relation to the sort of specter of the recent Chinese collection of federal employee data, it is very worrying, but I just want to point out, I'm sure our government's doing the same, right? So if you're a Chinese government employee, you know, guaranteed the U.S. has had very little legal constraint in gathering your data and hacking your governments. So this happens. We just have to keep that in mind. There is no perfect protection out there.
Okay, on that gloomy note, let's thank.
I hope we don't leave it with all of us on the panel agreeing with that last comment.
Let's thank our panelists for a lively discussion. Thanks so much.